This is Chapter 11, Introduction to Contracts for Business Law. So let's talk about contracts. They're legally enforceable agreements. And to be enforceable, you must have all these characteristics present. The first is an offer. So someone has to propose a deal. Then there has to be acceptance. When one party receives that offer, you must respond to it. Consideration. There has to be some sort of bargain that leads to an exchange between the parties. It cannot be a one-way street. Legality. The contract must be for a lawful purpose. If you enter into a contract for something illegal, say, for instance, selling heroin, that is not enforceable. Capacity must exist, so the parties must be adults and of sound mind. Then there's consent. So certain types of force or trickery will prevent the formation of a contract. And then lastly, in most cases, a verbal agreement is okay for some purposes, but in many more cases, the contracts have to be in writing to be enforceable. And contracts for land are a good example. Contracts that are for more service that's more than a year, that can't be completed within 1 year, those all require that the contract be in writing. So for example, if you rent an apartment, your contract needs to be in writing. Next, let's talk about bilateral and unilateral contracts. So with bilateral contracts, a promise is made by both parties. But with unilateral, only one party makes a promise that the other party can accept only if they actually do something. So a good example is if I lose my cat and I post a sign saying I'll pay $100 for anybody who finds my cat. If someone finds my cat, then I have to provide the reward to them. That would be a unilateral contract. Next, let's talk about valid, unenforceable, voidable, and void agreements. A valid contract is one that satisfies all the requirements. It has no problems in the areas listed previously. It would be then enforceable. An unenforceable agreement occurs when you intend to form a valid bargain, but some rule of law prevents enforcement. A voidable contract occurs when one party can legally terminate the agreement. And a void agreement is one that neither party can enforce because either it's an illegal contract or because one of the parties had no legal authority to make the contract. Next, let's talk about express and implied contracts. With an express contract, you have two parties that explicitly state all the terms of the contract. Most contracts fit into the express contract. There are also, implied contracts where your conduct or your words indicate that you intend to have an agreement. Next, let's talk about the sources of contract law. So first of all, we have the common law, which is, as we've discussed earlier, this is judicial opinion that forms over time. We also have this thing called the Uniform Commercial Code, or the UCC. And the UCC was created to facilitate the formation and enforcement of contracts in a nationwide setting. So as opposed to having to understand the rules of different states, most states have adopted at least some of the aspects of the UCC, not all. And UCC contracts, it's very important to note, they pertain to goods. Now, for the focus of this class, we're going to focus on the sale of goods portion of the UCC. Now, for non-contract enforcement, we have a number of methods. So one example is called promissory estoppel. And so with promissory estoppel, this is a possible remedy if there was no valid contract, but the plaintiff was injured based on a promise, a reasonable reliance on that promise, and some injustice that occurred. So in this case, the defendant makes a promise knowing that the plaintiff will rely on it. Plaintiff relied on promise, and the only way to avoid injustice is enforcement. Then we have quasi-contracts. And quasi-contracts are when the plaintiff gives benefit to the defendant, the plaintiff reasonably expected to be paid for the benefit with the